This review video covers negligence in sport. What is negligence? Well, we can define negligence as an unintentional tort in which an alleged wrongdoer doesn't intend the harmful consequences of their actions to another person, property, or their reputation, but nonetheless, they still have harmed someone or something in some way. This is one of the most popular and common lawsuits within sport. Therefore, it's absolutely critical for future sport management professionals to be aware of what negligence is. We can boil down negligent actions into two categories, essentially. The first category is an act of commission, and this is an action that a reasonably prudent person would not do. We can also talk about an act of omission, which is an action that a reasonably prudent person would do, but they didn't. Let's look at some examples here. You'll see in the boxes in yellow on the left hand of your screen 2 examples of an act of commission. So basically, with this first example, this is a personal trainer asking a client to do a box jump knowing that they have a knee injury. This is not something that a reasonably prudent personal trainer would do. However, they did it. Therefore, we could label this as an act of commission under negligence. The second example relates to a head coach running onto a field after their athlete suffers an injury and a suspected spinal cord injury, and then they move that athlete. Again, this is something that a reasonably prudent person would not do. 1, because the head coach is not a medical professional, and 2, anytime there's a head injury, we know you should not move that person. Let's compare these to 2 examples here for an act of omission, labeled in green on the right-hand side of your screen. So back to our personal trainer example. Personal trainer failing to spot their client during a bench press. Now, a reasonably prudent personal trainer would spot their client during a bench press exercise, but for some reason they didn't. Second example is related back to legal duties of coaches. So a head coach, especially in a tackling sport like football, if they fail to perform the legal duty of properly instructing their athletes how to safely tackle, that would be an act of omission, because a reasonably prudent coach would instruct their players to do that, but they failed to do so. Therefore, we can consider that to be a negligent action. Essentially, an act of commission is an action. So an act, when we think about conduct, and an act of omission is an inaction. Somebody fails to act on some type of situation. There are 4 elements of negligence that have to be proven in order to have a successful lawsuit from the perspective of a plaintiff. Now, the plaintiff has the burden of proving their case whenever they allege someone for being negligent. And they have to prove all 4 elements here listed up on the screen. If they fail to prove all 4 elements, then the negligence case fails. We'll break down each of these elements right now in this video. The first element of negligence is called duty of care. This is sometimes called standard of care. The duty is defined as a special relationship between 2 or more parties that's created either by statute, so a law, contract, or common law. And we consider duty of care to be the threshold for a negligence lawsuit. Without establishing that someone has a duty of care towards somebody else, then there's really no legal footing to even allege negligence has occurred. Another way to view duty of care is responsibility owed. All right. So this means that there has to be a relationship between 2 people and one person owes the other a responsibility. The defendant owes the plaintiff a responsibility. So without a relationship between 2 parties, then there's no responsibility that's owed and there's no duty of care. However, an example of duty of care is a relationship between an athlete and a coach, right? A coach is responsible for the athlete's well-being and safety under their care. They have a relationship. Now, is the opposing coach of a team responsible for an opposing player? No, they're not, right? So there has to be a relationship between the 2 parties in order to demonstrate that there is a responsibility owed. The second element of negligence is called breach of duty. So moving forward right from our conversation with duty of care, the next step is after you prove that there is a relationship between the plaintiff and the defendant, you then have to prove that that duty of care was breached. So that responsibility somehow was not followed through with. Essentially, what we're looking at with breach of duty is how would a reasonable person act in this situation? And then how does that compare to what actually happened? So this is essentially determined on a case-by-case basis, and that's because duty of care differs tremendously depending on the nature of the activity or the sport, the context. That's why we're looking at and we're comparing how would a reasonable person act in this particular situation, and how does that compare to what actually happened? And that brings us back to our conversation related to active commission or active omission. So this relates back to conduct, right? So in this situation, someone may act in a way that's not reasonably prudent, or they might fail to act. They might fail to show up in some way, shape, or form. So essentially with breach of duty, what you're looking to do, what plaintiffs are looking to do, is that they are trying to indicate that the defendant's conduct, so their act of commission or act of omission, impose some unreasonable risk of harm onto the plaintiff. And this is established through a variety of ways in the eyes of the court, whether that's rules and regulations for specific facilities, sports, etc., case precedent, or even professional organization standards. The third element of negligence is called proximate cause. Proximate cause occurs whenever the defendant's breach of duty actually and proximately causes the plaintiff's injury. So essentially with proximate cause, you're looking to establish an actual and significant link between the conduct of the defendant and the resulting damage to the plaintiff. Now, the defendant's conduct, aka their action or their inaction, doesn't have to be the sole cause of the plaintiff's injury, but it has to be a significant cause of the plaintiff's injury. When we look at proximate cause, we have to establish arguments for both questions. The first is there causation in fact? So what the court does with this is they use something called the but-for test. But for the act, the injury would not have occurred. So essentially with this, they're looking at, because is there a direct link between the defendant's action or inaction and the actual injury? So that's establishing the initial linkage. The second question, were the defendant's actions a proximate cause of injury? This is when we're looking at the significantly aspect of the linkage. So this means that the requirement has to be proven, whether it's a direct link and then a strong link between the defendant's conduct and the plaintiff's injury. So after we've established in duty of care a relationship between two parties, the plaintiff and the defendant, we then have proven in breach of duty that the defendant's conduct imposed an unreasonable risk of harm to the plaintiff. Proximate cause indicates that the defendant's conduct was an actual and significant cause of the plaintiff's injury. We then get to our final element, which is suffered damages. Suffered damages basically indicates that an actual harm must have occurred. Essentially, this means that the plaintiff has to have suffered a significant injury, whether that's physical or emotional, and this is determined by the court on a case-by-case basis. The most frequent remedy to this is financial compensation. So these are the four elements of negligence. And again, I want to drive home these 2 points here, that the burden of proof is on the plaintiff. It is the plaintiff's responsibility to prove that the defendant has met these four elements, and that all four elements must be proven for a successful case. And that concludes our wrap up on negligence in sport.